My name is Jada Davis. Our group consists of Megan Finger, Gabrielle Heyer, Mackenzie Maury, and Megan Roshak. And today we will be presenting to you on trademarks. A trademark is a word, name, symbol, or design used to identify a company's goods and distinguish them from similar products other companies make. There are many things that can be trademarked, such as letters, numbers, domain names, shapes, slogans, sounds, and even smells. Consider the three stripes for Adidas or the Nike swoosh. When you see these symbols, you automatically think of the company. However, in order to be registered for a trademark, something or the item has to be distinctive. There are 4 types of distinctive marks that represent how likely something is to be registered for a trademark. The spectrum goes from most likely to least likely, with fanciful marks, arbitrary marks, suggestive marks, and descriptive marks making up the 4 categories. Now let's get into a little bit about why we chose to do trademarks and focus on this topic specifically. Understanding trademarks and distinguishing them from things like copyright and patents and anything regarding protecting intellectual property can become confusing to just about anyone. Especially if someone is interested in protecting their intellectual property, it is good to know what kinds of protections exist in order to choose what's best for the business or property that they're trying to protect. We wanted to provide some clarity on this specific type of protection to distinguish it from the others. We also chose this topic due to its role in pop culture. This pop culture environment that we live in is driven by intellectual property and using it as a source of revenue and entertainment. Rightfully so, we will discuss just how trademarks exist within pop culture. Here are just a couple of trademark issues that have occurred in pop culture, just to make our presentation a little bit more interesting and relevant. First, we have the Ringling Brothers Circus that ended its 150-year run as an operating circus in May of 2017. The show had acquired worldwide fame as the greatest show on earth. This tagline became so synonymous with the circus that the owners got trademark registration on the phrase. Even though the circus had ended, the trademark registration still lives on. Unfortunately for Kid Rock, the owners of this trademark registration are now suing him for trademark infringement after branded his upcoming show as the Greatest Show on Earth tour. While the owners are no longer promoting a live circus, the trademark registration is still actively licensed for things like apparel and toys. Their long history of using this trademark provides ample support in the trademark infringement suit filed against Kid Rock and his concert tour. Next, we all know the magical world of Harry Potter, created by J.K. Rowling. This magic quickly spread as one of the most valuable intellectual properties in the world. The value of the Harry Potter trademark took off at an exponential pace. Scottsville, Virginia has hosted a Harry Potter festival annually. Locals and shop owners have transformed themselves into honeydukes, the Ministry of Magic, and other aspects of Harry Potter. With an empire now growing at the Halloween Festival in Scottsdale, Virginia, dedicated to the Harry Potter world, trademark issues have caused this festival to be canceled. Next, Megan will discuss the history of trademarks. So we will now be taking a look at a timeline of different court cases that had to do with trademark, and I'll be sharing some specific details from each one. The timeline begins in the 80s, as you can see, and will actually end up in current day and some cases that are still pending. So we'll be reviewing just the important details and kind of the stuff that's applicable to today. And before I touch on any of them, I want to briefly explain the Lanham Act to you, since that will come up quite a bit. And it's also known as the Trademark Act of 1946. So this gave some regulation to trademarks, how they can and can't be used, and how that all works out when they are brought to court. And overall textbook definition is that it's a federal statute that governs trademark, service marks, and unfair competition. So starting off, the first case that we're going to look at is in 1988, and it's versus Kmart Corporation versus Cartier. So this case opened up the conversation about gray market goods, and gray market goods are defined as goods that have genuine trademarks. So they have the real logo on them, but they're imported without consent of the domestic owner of the trademark. You may also run into quality discrepancies between the gray market good and the authenticated good. This really isn't clarified today, and it still is a bit of a gray area itself. It just kind of depends on what cases are decided. This is one of the cases that the Supreme Court took, but they didn't necessarily make a statement in it about gray mark goods and their legality. There's still a gray area with it for sure, but it did address where these disputes can be held, and they said basically it was up to a jury. The next case we'll be looking at was in 2000. So this was Walmart Stores Inc. versus Samara Bros. What Walmart did was they took clothes from Samara Bros, like kind of like their prototypes, showed them to their own designer, and then ended up selling almost copies of the clothing with some little differences within their stores. So the question arose from this case: under the Lanham Act, is a product designed distinctive on its own to be protected from infringement? And the answer was no, that you can still have knockoffs, and you probably still see that in Walmart today, where they'll have items that are maybe kind of mocked after the designer items that you wouldn't typically be able to get there. So now we're moving closer to current day, and we'll start in 2014. ABC Inc. versus Arrow is the first case we'll be looking at. Arrow offered a streaming service of currently on-air TV. So let's say you were using their service on your laptop. You would be able to view anything that someone sitting on their couch watching the TV was able to view. Now, obviously, this took revenue away from cable providers, and they were not happy about it. The question arose: does a company publicly perform a copyrighted television program when it transmits the program to paid subscribers over the internet? And yes, this violated copyright laws and the Lanham Act. That's where that language comes from. Publicly perform is the Lanham Act. Getting even closer to current day, we have this 2019 case. It's really interesting. Brunetti wanted to trademark the mark FUCT, which sounds a little bit like FUCK when you actually say it out loud. He was not successful because the pronunciation of it was vulgar or scandalous, and that's how they were kind of arguing that he couldn't have that mark. The reasoning that a trademark could be blocked because of vulgar language in Section 2 of the Lanham Act was ultimately found to be violating the First Amendment. You can't just say, we're going to squelch this speech because, oh, it's offensive. We've talked about the First Amendment in class. We know that it protects a lot of our speech. So that question was brought before the court. Does this violate the First Amendment? Yes, it did. And Alito suggested that maybe Section 2 of the Lanham Act should be reworked so that you could still eliminate vulgar marks and not have to trademark them, but to word it in a way that didn't violate First Amendment rights. So the last case that we're going to look at is a current day one that is still pending. So this is the U.S. Patent and Trademark Office versus Booking.com. Now, under the Lanham Act, like I said, that one will come up a lot. Marks have to be distinctive to be protected. Booking.com has run into some issues with that. So booking is a pretty generic term, since you can book a room anywhere, you can book a flight anywhere.
and .com alone is for commercial use. So can the combination of booking.com really be eligible for trademark and actually be protected? And that case, we'll have to just wait and see how it plays out.
Now let's take a look at the Supreme Court case Maddle v. Tam. Simon Tam and members of his Asian American band, the Slants, wanted to register the band's name as a trademark with the U.S. Patent and Trademark Office. The office rejected the application based on the fact that the name was belittling and offensive to people of Asian descent. The PTO cited the disparagement clause of the Layman Act of 1946, which forbids trademarks that consist of or compromise immoral, deceptive, or scandalous matter, or matter which may disparage or falsely suggest a connection with persons living or dead, institutions, beliefs, or national symbols, or bring them into contempt or disrepute. Tam appealed the decision and went to the U.S. Court of Appeals for the Federal District, which reversed on grounds of the Free Speech Clause under the First Amendment. The question being asked here is whether or not the disparagement clause is invalid under the First Amendment. Trademarks are not found as government speech. The government speech doctrine allows the government to communicate its own viewpoints without discrimination or violating the First Amendment. The court raised some concerns about this expansive view of this doctrine. Quoted, if private speech could be passed off as government speech by simply putting a government seal of approval, the government could silence or muffle the expression of disfavored viewpoints. The court ruled in favor of Tam. The disparagement clause prohibits trademarks that disparage members of a racial or ethnic group and violates the free speech clause under the First Amendment, from Justice Alito. The court ruled that government cannot ban expression merely because it is offensive. Alito rejected that argument, saying that trademarks are private speech, not government speech. He was quoted holding that the registration of a trademark converts the mark into government speech would constitute a huge and extensive extension of the government speech doctrine. He continued to write, saying, for if the registration of trademark constituted the government speech, other systems of a government registration could easily be characterized in the same way. Now, Gabby's going to talk about a little bit about the analysis.
The U.S. Patent and Trademark Office, following the disparagement clause of the Lanham Act of 1946, effectively limits free speech provided by the First Amendment. To be able to limit free speech, the government must pass a strict scrutiny test. This standard was not met because free speech being limited based on discrimination only applies in cases of fraud, defamation, and incitement, in which this case does not fall under. Justice Alito stated, the disparagement clause was also not a permissible regulation of commercial speech because it was not narrowly drawn to serve a substantial interest. The ruling also kept the disparagement clause in check to protect against discriminatory acts at face value, instead of having a broad focus on whether there was any possible way phrasing could be interpreted as discriminatory speech. Now for the conclusion of this case. Justice Samuel A. Alito Jr. delivered the opinion of the court, which was 8-0 in favor of Tam. Justice Neil Gorsuch did not participate in this case. The Patent and Trademark Office limiting free speech based on possible discrimination was beyond the authority granted by the disparagement clause of the Lanham Act of 1946.